Hello everyone, I'm Helena Dalton-Bridges, and I'm here this afternoon with Laura Fraser Hardy. This is the second of our toolbox discussions that we're putting through as part of our webinar series for you to be able to view at work or at home, particularly looking to help you with workplace issues. Now, they are CPD events, so as part of that process, if you stay on for an hour, we'll ensure that you have one CPD hour appointed to your record with us. So this afternoon, as I said, Laura is here from Hall Payne Lawyers. Laura is, she's worked in industrial relations and employment law for nearly 10 years. She's a senior associate with Hall Payne, and she's particularly interested in discrimination law as well as in the anti-discrimination and bullying jurisdictions in the Fair Work Commission. Today, Laura is going to speak about the principles of natural justice, and after she's spoken, there's going to be some time for some questions. If you'd like to ask questions, please type them in, and our staff member will be able to receive those and then feed them through to Laura. It's on the right-hand side of your screen, so you'll be able to see the question button, and you can do that at any time throughout Laura's presentation, but we will go to them at the end. So I'm sure you're going to enjoy the session with Laura this afternoon. It has been prepared with Paul Spotto as well. And thank you so much for joining us. See you soon.
Well, good afternoon, everyone. It's nice to be online with you all. As Helena said, my name's Laura Fraser Hardy, and I'm a senior associate at Hall Payne Lawyers. It's great to be with you having a bit of a chat about natural justice, which has an application for you as an employee across, I guess, both your employment and your registration as well. But natural justice as a concept has quite a long history. For example, in 1885, Lord Esher described natural justice as the natural sense of what is right and wrong. Whilst the expression has been said to be lacking in precision, it's now widely accepted that natural justice, as it relates to matters associated with the employment relationship, is concerned with fair treatment of the employee in their employment. So today we're going to be having a look at a number of different aspects. The first one is, what is natural justice? We're also going to be having a bit of a look at what natural justice is as opposed to procedural fairness. And you might have seen in your employment that both the terms natural justice and procedural fairness have been words that are interchanged quite readily in those matters. We're also going to discuss how natural justice can be and is achieved, and also have a look at how what the relationship of natural justice is in both the public and in the private sector for you. I understand that there's both public sector and private sector employees online, so that's a bit of a brief overview of what we will be talking about. So natural justice consists of a number of principles, and these came from judge-made law. And as I outlined before, it's accepted that natural justice is concerned with the fair treatment of the employee in their employment. But there's a number of main principles around natural justice, and these principles came from judge-made law. And those principles are, the first one is the right to be heard. So something should not be done to a person that will deprive that person of some right, interest, or legitimate expectation of a benefit without the person being given an adequate opportunity to present the person's case to the decision maker. The second principle is the absence of bias. Again, bias is probably a term that you might have come across in your employment matters, but the overall test of whether a decision maker is biased is whether the relevant circumstances would give rise, in the mind of a party or a fair-minded person, to a reasonable apprehension or suspicion of a lack of impartiality on the part of the decision maker. For example, one employee should not be treated more or less favourably than another employee, for example, in singling out that employee, and an unbiased and impartial decision maker be appointed. So, for example, if there is a grievance within the workplace, you would want the person who's going to be making a decision about that grievance not to be somebody who's involved in that grievance. So you want them to be unbiased and not involved in that process. The third principle is the principle of procedural fairness. Now, procedural fairness involves, it's a flexible obligation to adopt fair procedures that are appropriate and adapted to the circumstances of a particular case. So what might be fair and reasonable in one case might be different to that of another. Procedural fairness is necessary to find the finding of reasonable management action. And practical examples of procedural fairness might include the clear communication of policies, procedures and instructions. For example, your employer would hopefully have the relevant policies and procedures that would apply to your employment, the grievance procedures and any disciplinary procedures available to you in some way. It's also likely that when you commence employment that you might be required to read through those policies, the codes of conduct and that kind of thing as well. But another issue and another practical example of procedural fairness is the promptness in initiating and taking action. So for example, if a complaint is made about you in February of 2016, it's entirely unreasonable and unfair for that to later be brought up with you 9 or 10 months later when it wasn't dealt with you. You didn't have an opportunity to deal with that matter at the time that it was first raised as an issue in relation to your employment or practice. So you wouldn't want those kinds of things to be saved up for the future or an employer to gather different issues and then deal with them all as a lump sum, sometime after the event might have occurred. Other examples of procedural fairness might include the issuing of warnings, either verbal or written. Employees need to be aware if you're being issued with a warning. There's no point in an employer drafting correspondence, sending correspondence to a wrong address if you never actually receive it. So you need to know that you've received that correspondence. The information to be provided to an employee must be sufficient information to give that employee an opportunity to appropriately respond to an accusation. So you might hear us, if there is an employment matter, talking about the particulars that might relate to an allegation. So for example, you would need the date and the time and what it might be alleged that you've said and the circumstances in which that might have occurred to have given you a proper opportunity to respond to the allegations. Another example of procedural fairness might be your right to representation, and that also includes your right to have a union delegate present during the course of the meeting. Your right to respond to allegations is also a matter of procedural fairness, as well as knowing and accepting that your decision maker and hoping that your decision maker will be giving full consideration of the relevant facts and circumstances when making a decision about a matter. Further, when a decision is made, another example of procedural fairness is that those reasons are communicated to you in an appropriate manner. Another example of procedural fairness, there is quite a few, is that documentation is compiled and maintained throughout the aspects of the process. So for example, if a performance improvement plan or a learning contract in your workplace might be developed, you would want to make sure that at the first instance that it's discussed with you, that at the different times when you are assessed against that learning contract, that it has been appropriately recorded, that you're given an opportunity to respond, and at the outcome, at the end of that process, that it's clearly recorded what is the outcome. What is the point of having such a performance improvement plan if you can't actually see the process that has taken place and what the outcome is at the end of it? So as you can see, procedural fairness is in fact is a specific name for what is a large part, but only one aspect of what natural justice is in its broadest sense. And procedural fairness is concerned with the procedures that are used by a decision maker rather than the actual outcome that's reached. But what is confusing is that the term procedural fairness is quite often interchanged with that of natural justice. There we go. It's one aspect of natural justice concerned with procedures and used interchangeably as well. So in a nutshell, what does it mean in practice? It means that fundamentally an employee must be aware of policies, procedures, and instructions in the first place. They must be advised of the reasons for any disciplinary action that is taken, particularly in circumstances of dismissal. The employee must be afforded a fair hearing and the opportunity to present their case prior to any adverse decision being made. Importantly, in natural justice, what we must do to uphold that is that we have to agree that there is a presumption of innocence, and you see that that's just come up on the slide there. Essentially, an employee has a right to the presumption of innocence until it's proven otherwise. And that standard of proof, which you've probably also heard of, is to prove that on the balance of probabilities. It's important that your managers are not assuming guilt and that they treat an employee as if that they don't treat that employee that they are guilty until it's been shown that the employee is truly at fault and after they've been given the opportunity to have their side of the story heard. It's not enough that the employee is heard. The manager of the process must eliminate any actual or appearance of a wrong or unfair decision being made. The manager cannot, for example, allow anyone who is a party to an event to be involved in any deliberation as to whether a certain person is wrong or not. So it's quite important that your employers do uphold those particular principles, as of course it can become unstuck in the event that you decide to take a matter further. For example, if there's been a termination of employment. So, and again, just coming up there is the standard, which is on the balance of probabilities and no unfairness, whether actually or in appearance. So it's quite important that there's both no appearance of bias as well as any actual bias as well. So the modern evolution of the duty to observe the rules of natural justice has seen the scope and the doctrine broaden quite significantly. And particularly you'll see that in the public sector. And interestingly, and probably for all the right reasons, natural justice and principles of natural justice are enshrined within the legislation surrounding public service employment, and it's certainly reflected in many of the policies and procedures that apply in public sector employment as well. So natural justice particularly applies to disciplinary processes that are undertaken under the Queensland public service statutes and legislation. And in particular, I'd like to draw your attention to section 190 of the Public Service Act. There's actually, I'm sure it's not particularly interesting to you, but it's interesting to me that there's a new version of the Public Service Act that is actually, I believe, relevant as of the 7th of March of this year. So section 190 of the Public Service Act I've put on the slide there for you. And that says that in disciplining a public service employee or former public service employee or suspending a public service employee, a chief executive must comply with this act, any relevant directive of the Commission chief executive, and the principles of natural justice. However, natural justice is not required if the suspension is on normal remuneration. So this is particularly relevant in processes of disciplinary action in the public service. So the non-requirement, as you can see in subsection 2 there, for an employing agency to have to comply with natural justice when an employee is suspended on full pay is surprisingly lawful, even though, as outlined in the previous subsection, natural justice is a fundamental part of the process. And the reason that they say that they allow it is essentially because they say that it's an administrative process to remove an employee from the workplace. So, for example, if there's a very serious allegation relating to discrimination or sexual harassment within the workplace, it might be necessary to remove that person from the workplace while an investigation is ongoing as an administrative process. That's not to say that any finding of guilt has already been predetermined in respect of that employee. but certainly until you know that there is no risk, it may be reasonable to remove that person from the workplace. So notwithstanding the exclusion, the requirement for natural justice to be afforded to a public sector employee before making a decision on any allegation and disciplinary action is further prescribed in Queensland Health's Human Resources Policy E10. And I'll refer you there to clause 3, I believe, of that document. Now, these documents are all available to you, and I presume that if you are a public sector employee that you would know where you might be able to find these documents. And certainly I imagine that the union would be able to point you in the right direction, or your managers, if you had any questions. But essentially there are two clauses in this document that relate to natural justice. And the first one is section 3. And that section says that the principles of natural justice must be applied when undertaking the disciplinary process. Natural justice must be afforded before making a decision on an allegation and any disciplinary action. So that, again, it's making sure that natural justice is at the forefront of any processes relating to disciplinary action. Just give me 1 second. They go on to outline some key principles. And again, it's quite good to read this, I think, because it does outline quite strongly for you what natural justice and the key principles around that are in these processes. It talks about how the key principles must be applied in the process, and that includes relevant legislation, applicable policy must be complied with. Allegations must be supported by objective evidence which has taken into account all of the relevant materials. The standard of proof, as we outlined previously, to be applied in making a finding in relation to a disciplinary matter is on the balance of probabilities. When practicable, all decisions should be made in a timely manner. You don't want to leave an employee, waiting, which is a very stressful process for an outcome in a matter when the more time that goes by and being out of a workplace can have a detrimental impact upon them personally as well. An employee must be advised that they can access employee assistance. There must be confidentiality. And I would note that in these disciplinary processes, many of the correspondence that you will receive will clearly outline what your confidentiality obligations are, and breaches of those confidentiality obligations could result in further disciplinary action being taken. Employees are entitled to discuss the matter with a support person, union representative or legal representative. That all stages of the process are to be documented and stored confidentially in a secure location and not to be kept on an employee's personnel file, and that there is a distinction between criminal processes and disciplinary processes. The document, the policy, clearly outlines what those obligations are, and certainly if you are represented by the union in these processes, I have no doubt that if natural justice isn't being followed, that it would be raised within the process itself as well. So the next document I wanted to mention is that natural justice is actually to be afforded in public service employment in the pre-employment process as well as the actual employment process. And this is in relation to the screening process. And we're pointing this out to demonstrate that, that it's not something that's isolated to the employment, but it's also to the processes followed both at the beginning as well as during the process as well. So specifically, when an applicant for a job, when that criminal history calls into question suitability for employment, the policy, and that's policy B40, actually provides a process which includes natural justice for considering that criminal history. So again, what the policy essentially says is that an applicant, if there is a criminal history that is of a concern or should be noted, the applicant should be given an opportunity to explain and to make submissions in relation to that criminal history prior to a decision being made as to whether or not that person is in fact suitable for employment. So it is quite interesting that it is quite clearly stipulated within the employment screening documentation as well. And the obligation, again, is to act fairly, without bias, and giving proper consideration to the submissions that might and the representations that are made by applicants in that process. So the last document that I wanted to raise as a document that also includes natural justice within public service employment is in the Queensland Health Human Resources Policy E12, which is around grievances. So nurses or midwives with a workplace grievance are required to have their grievance managed in a way which, and we quote from the policy, that natural justice to all parties, that affords, quote, natural justice to all parties to the grievance. And natural justice is in fact defined in that policy. The goal of the process in that policy is to have a procedurally fair decision that ensures both the hearing rule and the rule of bias is complied with. In practice, that means in context of a grievance, this requires that when material is obtained that may reasonably be considered to be detrimental to an employee's interest, that the employee is to be provided with access to the material as soon as practicable and given an opportunity to respond to such material. In particular, for example, a person might make a grievance which might be quite sensitive, and consideration needs to be given as to whether it's fair and reasonable in those circumstances to make sure that the full information relating to the grievance is in fact provided to the person to whom it's about. Material provided is to include the factual information to be examined and is to be sufficient enough, in enough detail, to enable adequate preparation of a response. However, provision of material to a party to a grievance is to be in accordance with other policies, such as the Access to Employee Records HR policy. And that policy specifies circumstances in which it is not appropriate to provide material to certain parties. Now, if these processes aren't followed, of course, review tribunals such as the Public Service Commission and the Queensland Industrial Relations Commission may overturn decisions if they're found to be procedurally flawed. And therefore, the role of decision makers in ensuring that all of the necessary steps are followed is an extremely important one. I do have an example of a termination, which I'll discuss with you later, where despite perhaps the circumstances giving rise to the termination, making that termination reasonable, unfortunately, due to the flaws in the procedural process, it was deemed to be an unfair termination. There are other relevant policies where natural justice is specifically mentioned to be afforded in Queensland Health, and that includes the Public Interest Disclosure Policy, the Mental or Physical Incapacity of Employees Policy, and the Performance Improvement Policy. So I certainly suggest that you have a look at those documents if they're relevant to you and any processes that you might have in respect of your employment. Note, however, that natural justice does not require a public sector employee suspected of engaging in misconduct to be given an opportunity to respond before a decision is made to commence an investigation into that alleged misconduct. And again, that's probably quite similar, I would suggest, to the decision to remove someone from the workplace, and that's because it's a decision of a preliminary nature. So a decision to investigate may not deem to be a decision that, because of its preliminary in its nature, it's not reaching a final decision or in respect as to whether or not the allegations can be made out. So generally, a decision made in breach of the rules of natural justice is in fact invalid and will be set aside from the date generally on which it was made, and consequently any sanction that's imposed relying on that decision cannot stand. Where the outcome of a flawed decision results in the termination of employment, the employee may apply for relief. A failure to accord a public sector employee natural justice is only one factor that can be taken into account when determining whether the termination was harsh, unjust and unreasonable. Where there's been a full review on the merits by a commission and the commission has found that the termination is justified, only rarely will a failure to accord procedural fairness during the disciplinary process result in the finding that the termination was harsh, unjust or unreasonable. So as I said earlier, natural justice has come about through judge-made law. the common law doctrine has wide application and it's presumed by the courts to apply to the exercise of virtually all legislation, including the Fair Work Act. And I guess this is where we start talking now about private sector employees. So while the words natural justice and procedural fairness can't be found in the Fair Work Act, procedural fairness is required to be afforded to private sector employees, particularly those who are facing disciplinary investigation. Failure of an employer to apply procedural fairness in those circumstances before an employee's dismissal will usually result in finding that the dismissal was unfair, either in the result in either the reinstatement of an employee, if that's appropriate, or the payment of compensation up to the equivalent of 6 months' pay. So the process, as well as the reason for the termination, is particularly important when considering whether a dismissal is unfair, unjust, and unreasonable. And again, the same kinds of things will be considered. Were you given an opportunity to respond? Were you given an opportunity to improve in your performance? Were you given an opportunity to have a support person present at the meeting? Did you have an appropriate period of time to allow you to respond to the allegations? Did you have all the information before you? Was the decision maker unbiased, and were they fair in their application when they considered the facts before them as well? So what does that mean for private sector employees? So like their public sector counterparts, they must be aware of any allegations that are concerning their conduct to enable them to properly respond to the allegations. So that doesn't mean simply going through the motions of giving the employee the opportunity to deal with the allegations concerning conduct when, in reality, for example, a decision to terminate had already been made, which would be adhered to irrespective of anything the employee might say in defence. So if an employer is going to go through a process, they must actually consider your responses. They can't have already determined what the outcome would be at the start of the process. So an employee facing investigation must be provided with sufficient information to understand the nature and the specifics of the allegations of which they're accused, and the information is sufficient for the employee to prepare and articulate a response to the allegations. So I just had a couple of decisions before I finish up that I just wanted to speak about. The first one is actually a decision in the Fair Work Commission. And this is a decision which actually involves a circumstance where there were 3 employees and they were accessing pornography on their computer system. Their employer had policies and procedures relating to the access of that kind of online material, had policies and procedures about the kinds of emails that you send and whether or not, whether such conduct could amount to sexual harassment, for example. So, and I believe, I think in this circumstance, when they logged onto the system, they were acknowledging that they were logging onto their employer's system and that these policies and procedures applied to them. So despite them accessing this material over a really significant period of time, which you might suggest that would be sufficient to warrant the termination of employment, the actual finding was that there are a number of issues with the process that was followed during the course of the investigation. So firstly, I believe that when the matters first came to the employer's attention, they didn't take any action immediately to prevent ongoing actions of that nature. So they were aware, and then 6 months later the conduct was still ongoing. So that would suggest that they failed to take action immediately in respect of the alleged issues. So that was one of the issues that was certainly raised and certainly didn't give them the opportunity to respond when the matters first came to the attention. So in that particular circumstance, and there were a number of other issues as well in that matter, but interestingly, the outcome was because of the failures in respect of the process and the procedures that were followed by an employer, it was found that the termination of their employment was in fact unfair, unjust and unreasonable. And in their instance, they actually got their jobs back and they were reinstated. Not that I'm suggesting that anybody engage in such conduct at all in the workplace. But I only raise that as an example because process is important, and that it can be, you know, the major factor that could lead to, you know, the reinstatement or certainly a better outcome for an employee. I also have a decision in front of me, which I won't speak about too long, other than to say that it's a decision that talks again about processes within Queensland Health. And what is interesting to take from this particular decision is that Queensland Health properly documented the process and at all times gave this particular person an opportunity to respond to the allegations that were raised against her. So when they had issues that were presented to her, she was given that opportunity to respond. They considered it, the matter went on. In this case, it was certainly found that because they were able to document and demonstrate that they had given that opportunity and they'd given appropriate timeframes to respond, that it wasn't an unfair process in that respect, an unfair dismissal in that respect. So it is important to note that there's a variety of different circumstances within which natural justice is going to be a particularly important issue. And we would certainly suggest that if you have concerns about natural justice and whether they're being afforded to you within a workplace process, that you're certainly documenting what is occurring, and that you are raising that with your representatives at the time. So that is all that I had in terms of a formal presentation today, but I'm happy to answer some questions as well.
Thanks so much, Laura. That was a really informative presentation. We've got a couple of questions from members, so I was just wondering if I'll just pop off to the side here.
Sure.
So the first one we've got is, in your experience in representing our members, do breaches of natural justice principles occur very frequently?
I think that they occur, So I think that they probably do occur, particularly in circumstances where the process hasn't been commenced from the beginning, utilising the processes, utilising the policies and processes. But generally they would be. It's just a matters can often get quite complicated, and I think that is where there has to be a really clear definition and a clear outline what the process is actually going to be. So I would suggest that perhaps when you don't have an experienced manager, for example, it might be harder to make sure that the proper processes are being followed in those instances.
Okay. So in that case, if you think you haven't been afforded natural justice in a decision that's been made at work or in a process, what avenue is open to you? What can you do about it?
Yeah, so again, depending on what the process is, there could be an appeal process. It could be that there's, in fact, a grievance process that's available to you because you haven't been afforded the proper process yourself. And certainly we would suggest that contacting the union is likely to be your first port of call in respect of having that discussion about what can be done next. And certainly if it's resulted in termination of employment, it would be something that we would be, examining quite closely as well.
So members are always, we always recommend really strongly that they contact us in the first instance as soon as something concerns them, and that they are documenting all the time so they can give us as much information as possible. It's important, isn't it, that members have the time to respond to an allegation and that they're given access to all the materials they need. Occasionally we hear circumstances where members are asked to produce a statement, for instance, before they leave a shift, or that they're asked to write about an incident. And whilst it might seem quite straightforward at the time, it's important that they seek advice first in regard to those principles, but also that they've given access to the materials they need and also advice in regard to those statements they might make.
Yes, I think there's a bit of an overlap in terms of what you're talking about in terms of
making a statement.
Making a statement and for what purpose you might be making that statement. So it might not be, it might be something that is relevant to a complaint being made to the regulator about practice or conduct, and it might not be your own practice, it might be the practice of somebody else you might be the person who's observed something that's occurred within the workplace. And again, there's a couple of things. Firstly, making notations or doing writing something down as soon as you get home is probably a really good way of recording what happened in that shift. If you've gone to a shift and you know that something's occurred which is out of the ordinary, you know that there's a possibility that you could be asked questions about it at the time. There's nothing to prevent you from making a notation about it when you get home. And the benefits of that is that it's clear in your mind, it's just happened. Yes, you don't have the benefit of accessing the medical records which would support or demonstrate what's occurred during the shift, but you still have a pretty good recollection. And if you're going to have to rely on that in the future, the notation that you make around that is, well, I made this when I went home, it was fresh in my mind, I didn't have access to the medical records at the time that I made it. And there's nothing wrong with that.
So thank you. So again, it's really important for our members that they do contact us as soon as possible. We don't want to have to get lawyers involved where we don't need to, but it's important to know that we do have people like Laura and Paul who are with us today who can get involved in these processes, which can become quite complex and quite legalistic and involve different jurisdictions and forums. In a case where something looked quite simple to begin with and then spiralled out of control. And of course, we've heard lots about unfair dismissal, and unfortunately in many matters natural justice principles are called into play in regard to unfair dismissal. So, but it's not only that process, it could be in any other disciplinary matter, either in a private or a public setting. So please contact us, and again, thank you very much, Laura. Laura's webinar will be available on our website as well as the slides if you need to access those. We also have a quick questionnaire that will come up at the end of the webinar, and we'd really like you to be able to respond to it. It's only 4 quick questions. This is only the second of these presentations, and so we're really keen to hear your feedback. And again, thank you so much, Laura, and thank you so much, Paul, for joining us this afternoon. Bye.
Thank you.
Thank you.